With the legal risks of communicating sustainability higher than ever, sustainability communicators are hard-pressed to tell stories that are both compliant and compelling. Hey, everybody, and welcome to the Sustainability Communicator, the podcast exploring the intersection of corporate sustainability and storytelling. I'm your host, Mike Howard, a sustainability communication nerd with more than 15 years of experience on both sides of the podium, as a journalist for media outlets like GreenBiz and a communication strategist for major global companies. During each episode, we explore interesting sustainability communication challenges, risks, and opportunities facing folks in the business community and beyond. If you're ready to talk your walk, then you've come to the right place. Time to get to it. While greenwashing laws are in their nascency around the world, recent regulations in Europe and case law in the United States are beginning to shape their future. In Europe, the burden is on the companies to prove that they aren't greenwashing, while in the US, the burden seems to be on the consumer to prove that the company is the one making false claims. And as companies navigate this new legal landscape, they're going to need to tread carefully with their sustainability communication efforts. So today, I'm bringing on somebody who is both a legal and ESG expert. A rare combination, but something that's increasingly important today. I'd like to welcome my friend Christine Uri, who is the founder of ESG for In-House Counsel. Thanks for being here today, Christine.
It's my pleasure. I love being able to talk at this intersection of sustainability, ESG, sustainability communications. There's a lot going on.
So the first question I want to ask is just kind of getting to the basics of what are the legal definitions of greenwashing?
So, Mike, I have a really legal answer for you. There is no definition that would put it in a it depends type category. So the definition of greenwashing really changes from jurisdiction to jurisdiction and depending on the kind of products and services that you offer. The overall theme or what is considered greenwashing is a statement that is misleading or false or fraudulent with respect to environmental performance of a company.
Companies have been greenwashing for decades. So why is this happening now? Why is this only now drawing the attention of lawyers and regulators?
Yeah. I'm not sure I'd agree that companies have been greenwashing for decades, but they have been communicating about sustainability for decades, or at least a couple decades, and it is getting more attention now. There are a few drivers. First, people just care more about climate and sustainability now. So your public is spending more attention, watching what companies are doing, watching what statements are made. Second, there's a lot more statements being made. So because consumers and the public care about sustainability, companies want to look like they are acting responsibly. As a result, companies are putting out statements, and then those statements are available for the public to potentially criticize. And then finally, the increase in statements makes regulators want to act as well, want to make sure that companies are using sustainability communications correctly and effectively. And the regulators then draw out more communications and potentially more criticism.
I work with a lot of companies that operate both in the US and Europe. And right now, a lot of them are trying to figure out, how do I communicate sustainability in an authentic way that doesn't get me in trouble? In Europe, it might be violating some of the new regulations that are out there against greenwashing. And then in the US, how to avoid expensive litigation. Can you talk a little bit about the differences between the European and the US environment when it comes to talking about sustainability and greenwashing and the legalese that's happening around there?
The legal systems in the US and Europe are fundamentally different. In the US, we don't have a lot of regulations around what you say about sustainability. We do have a very active litigation system. And so what you're seeing in the US is a lot of consumer complaints based on false advertising or potentially fraud. These consumer complaints are coming up through the courts. And when a consumer complaint comes into a court, the consumer has the initial burden to show that a statement is misleading or fraudulent. In Europe, it's a much more regulatory-based system. Regulators put specific definitions around what companies can say and also what they must prove in order to back up those statements. And the regulations enable the regulators to hold the companies accountable, and often they'll provide a mechanism for consumers to also hold companies accountable if they violate the regulations.
So there's been a couple of recent cases in the U.S. in particular around greenwashing. Most recently, I was reading about how there was a court that ruled that Nike is off the hook for a potential class action lawsuit around greenwashing, saying that the plaintiff didn't have enough proof. Can you talk a little bit about this case? We don't have to go into huge detail, but just any high level takeaways, how this might kind of guide future cases around greenwashing in the U.S.
I did take a look at the Nike case, and in the complaint, the consumer made accusations that Nike's sustainability claims about its products were untrue, but the consumer didn't have any kind of scientific proof or didn't appear to have really dug in to see, beyond that particular consumer's opinion, whether the statements were untrue. So I think what the case will be more impactful for plaintiffs than for companies going forward. It provides guidance to plaintiffs' counsel on what kinds of information they're going to have to be able to back up claims against companies for greenwashing. And this is kind of it's a common method where plaintiffs' counsel over time learn what courts are going to expect and then modify their approaches to fit within those parameters.
So would you say that is it easier for a company to greenwash in the US than in Europe?
No, I mean, I think that the European regulations put a much higher burden on companies. In Europe, those regulations they'll apply to all companies. All companies will have to submit a certain amount of information and be held to a higher standard. The U.S. is different because what happens with the litigation is plaintiffs will pick a few high-profile examples. So you saw Nike. There's a big case against Delta for its carbon neutral claims. We just saw a case against Sephora. These plaintiffs choose larger companies as example companies and go after the huge amount of damages that's available in the US. So I think for your average company, you'll be held to a higher standard in Europe, and then your large companies in the US will be more at risk of this kind of litigation.
So in these cases, especially in the US, where the plaintiffs are claiming damages for greenwashing, what are the damages specifically? Generally, what are they talking about?
For example, I think all of the cases, the Delta, the Nike, and the Sephora, all three examples, the plaintiffs claim that they paid a premium because they believed the sustainability claim. And the cases are class action cases. This means that there's a lot of plaintiffs that are gathered together. Each plaintiff's claim may be relatively small, but if you aggregate them up, those claims get much larger. And then also available in class action cases is what's called punitive damages. Punitive damages are intended to punish bad actors by having the case or the results cost more than the actual damages, which may not be enough to influence behavior.
It's really interesting. Moving on to the specific regulations in Europe that are governing greenwashing in particular. I know the Green Claims Directive has recently come out, and a lot of us sustainability communicators are still trying to wrap our heads around this. Can you talk a little bit more just from a high level? What is the Green Claims Directive, and what does it mean practically for companies as they communicate sustainability?
Yeah. So the Green Claims Directive was proposed in 2023. I checked this morning. It hasn't actually been finalized within Europe, although it's certainly being watched.
Hmm.
Keep in mind that the European legal process is very long and from a U.S. perspective, convoluted in terms of making these regulations. If the Green Claims Directive does go into effect, it will require that companies have a certain amount of proof to back up statements that they make with respect to environmental performance. This could include net zero. It could include carbon neutral, although Europe is phasing out carbon neutral in general, or more general claims that a product is sustainable or green.
I interviewed you a couple months ago for my YouTube channel asking about this, but just to kind of reiterate, as a sustainability communicator, I don't have a legal degree, although I did think about going to law school way back when. Not going to do that anymore. How can non-legal sustainability marketers or communicators advise clients, or if they're working within a company, do their jobs without having all this legal knowledge? How can they tell stories that are interesting but also compliant at the same time? It sounds like sometimes those are at odds. How would you recommend sustainability communicators kind of move forward in this new era of legalese and regulation?
Yeah, it's definitely a changing environment. I mean, for a long time, these kind of sustainability communications lived within marketing and really didn't get much focus or review. It was more of a feel good story. And today, those process of communicating environmental performance has to go outside of that marketing context and really need the legal review to look at these greenwashing issues, but even a broader review than that. What consumers are asking for and what regulators are asking for is that if companies make a statement that a product meets a certain environmental standard, that the company has done its due diligence, has really done the work both to make sure the product hits that standard and to be able to document it. And so what needs to happen from a sustainability communications perspective is go ahead and write the communication and then just have a group that you start circulating it out to try to figure out, okay, what in here could be a flashpoint that we need to make sure we have some kind of verifiable evidence of. And keep in mind, a lot of the push will be around specific terms. So, if you want to tell a story about how you're reducing your carbon footprint, as long as the story is true and accurate, I think the storytelling portion should be relatively safe, although you should still have it reviewed. But when you start attaching a label to what you're doing, like this product is green, this product is clean, this product it only used, however much carbon, then you have to have some kind of backup to that state.
Yeah, it definitely makes a lot of sense. And I've been interviewing a lot of folks across different functions over the past months. And I think what's interesting is that traditionally, I think lawyers were seen as kind of the party poopers of sustainability communication. Like we would want to say something interesting and they would say, no, we can't say that. So there's always this kind of tension between, aspirational language, like we're going to do this, we're going to get there versus we don't want to greenwash. So I think that your advice is really smart where, as long as you bring the lawyers into the conversation, and I think lawyers also kind of understand now that sustainability needs to be communicated. You can't just green hush, and just kind of having that collaborative effort can really allow you to say things that are both compelling and compliant, as I like to say these days. Um,
Absolutely. And remember, my background is as both a chief legal officer and a chief sustainability
mhm.
officer. So I try to give the message within the legal community that you can't just say no to communicating on anything related to sustainability. Consumers, clients, regulators all expect transparency as a starting point, and companies need to be able to talk about the good things that they're doing. That's just a natural part of what companies do. There is some more focus on making sure that you find the right words to ensure that your communications are accurate. But I think overall that's a good thing for companies, a good thing. I know the sustainability marketing and communicators they want to make sure the claims are accurate. It's not like, you want to make sure you want to go out and make a bunch of false claims. So just a little bit more scrutiny while, not being too afraid to say something.
It's interesting since you've worn both the CSO hat and the lawyer hat. Some of our listeners are either in-house sustainability folks or they're consultants or they're communicators. What advice would you give both a sustainability practitioner or communications practitioner as they're trying to maybe engage with their internal legal team on these issues? Let's say you have maybe an in-house counsel that's not as familiar with the ESG or maybe is a little bit more on the conservative side around it. What are some tips on kind of engaging the legal teams on these issues?
Bring them in early. Ask your general counsel or whoever your legal leader is to appoint somebody specific to work with the sustainability team so that person can kind of learn the lay of the land over time and is responsible for developing that expertise. And then, like I was saying, bring them in early. the worst thing you can do is spend a year writing a beautiful sustainability report and then throw it over to legal 2 days before you're going to publish it with a, hey, could you take a quick look? Nobody will end up happy in that situation. So if you can create like just a little sounding board group where you're circulating drafts through, gives the opportunity for the legal counsel to have responses and then work through those responses, gives your legal counsel opportunity, if they don't know what a particular term is, to go get educated or for you to educate them on what that term is. And having someone just constantly engaged instead of, just at that last minute Hail Mary makes a huge difference.
Great. Well, that's all the time we have for today, Christine. Again, everybody, Christine Uri, she's the ESG guru for in-house counsel, and she works with companies of all sizes on basically the intersection of anything ESG and legal and sustainability related. She's got a lot of great content on LinkedIn, so definitely give her a follow. We'll include those in the show notes. And thank you, Christine.
Yeah. Thanks for having me on the show.
And with that, we've reached the end of this episode of the Sustainability Communicator podcast. Thank you so much for tuning in today. If you like what you heard and you'd like to hear more, stay tuned for future episodes that cover a variety of topics in ESG and sustainability storytelling. To stay in the know of future episodes and other content, you can follow me, Mike Hauer, on LinkedIn and subscribe to the Engage newsletter, which comes out about once a month. You can find those links in the show notes. And if you enjoy the Sustainability Communicator podcast, it really helps us out if you can tell a friend about the pod, forward it to one of your colleagues or friends or family members, and also give us 5 stars on Apple Music, Spotify, or wherever you're listening. Wherever you are in your sustainability journey, good luck and keep at it. We need you out there.